Mike.
No,
All right, we're on. It's October 22nd, 2015, bargaining session between Pasco County and International Brotherhood of Teamsters, Local 79. I'm Jim Sheriff.
Randy Tvist.
Pam White.
Ed Zietzik, Utilities.
Jim Boucher, Transportation.
Representing Local 79, John Schultes.
Doug Eck, Utilities.
Frank Sullivan, Utilities.
Tom Logan, Pete.
I'm John from Facilities.
Kevin Fulford, HR.
Barbara Hitzman, HR. All right, well, just taking from where we left off, do you wanna just go through kind of the contract, just article by article again? and see
Whatever you,
where-
whatever you think would be,
So we pick it up at 3.
All right, so
That's still
3,
open.
all right, 3 is still open.
I guess, you guys have, copies that were given out last time at least.
Yeah, so
think
I'll
from
just,
last
we'll,
time.
we'll mark them and I'll tell you, 'cause 3 I made some changes on, so I'll pull them aside. I'll go over the changes and then I'll have Kevin, he'll mark the pages, and then we'll just go make copies of those pages. Yeah, we'll take like a break right after we go through them. And so I'll just go over the changes that I made. So on page 4, there was no change. On page 5, we spoke about changes in G.
Is it basically anything that's shaded is considered?
Not always, so probably, but I think not always, it's whatever the computer decided to sometimes do. Unfortunately, it's only color, so it doesn't come out in here. We're getting a color copy, make sure,
Cool.
yeah, eventually.
Congratulations.
21st century.
Once we have my.
Yeah.
What
Don't
is
have it.
What
It's
is
almost
this, 2015?
1997.
2015?
One
Moving
day.
it forward.
Came out with them in 1900?
It's one of those
There'd
things
be
that,
something about that
you
Windows
know.
98.
Yeah, we just got 2000.
Yeah, we are
so
behind
all
the
good.
times in a lot of ways.
It's allocated from what will be left over for your salary for
That's-
you when you depart.
Yeah,
That's
exactly.
okay.
So
All right.
They can
you'll
take
be
it out of my
replaced by a color
retirement.
printer.
So where I added, actually, the sentence above that, which is just underlined for some reason, it says, unless related to substance abuse, alcohol or drugs, or any type of workplace violence, written reprimands older than 5 years and suspensions older than 7 shall have no weight when considering progressive discipline, but may still be used to establish that an employee received notice that the act or omission which gave rise to the reprimand can result in discipline. All disciplines related to substance abuse or violence in the workplace shall count toward progressive discipline regardless of age. And that's the new language that we discussed last time.
Just on that, I mean, if something's, not having weight, but it still may be used to establish, doesn't that kind of cancel it out? I mean, why would you have the need to establish, that an employee received something if you're not giving that weight?
John, that's the first element of a just cause discipline, is to establish that the employee had noticed that an act or omission could result in disciplinary action. So the purpose of that language is to negate and satisfy just that one element of the 7 elements of just cause discipline.
So, for instance, and I'll give you a perfect for instance, if an employee is tardy, and let's just say the contract, I don't know what the career service manual says off the top of my head, but let's just say it said that, you know, the 3rd time you're tardy, you can be suspended. Well, you know, like I said, if we end up, suspending someone, we couldn't use any of those tardiness that occurred in the last 5 years if they were written for the progressive nature of that, the 1, 2, 3, but we absolutely could use it to show that the employee was notified of the fact that they were tardy in the past and again, so. All right, so page, so you got that, right?
Yeah.
Cool, okay. All right, the next, drug-free workplace, we just went back to the status quo because you indicated last time, as we agreed, that random testing is in there, no need to change it.
I'm sorry, what page on?
I'm sorry,
Drug-free.
page 7.
All right, so we will copy that for them, because you brought that.
Yeah, you wanna do that?
Sure.
That's fine. So. Alright, I think collateral documents, I didn't change anything this last go-around. I think that just said last amended November 2014, so I don't know if we TA that or not. I mean, is there some reason we're not TAing that at this point?
Well, the only concern was to verify what changes were made in the last amendment period, and we just kind of I keep kicking the can. I mean, from what I understand, the only changes that were made were the change of the title of personnel director to human resource director. And unless someone, if that's all that was changed, or.
We gave you the marked up
Well, I understand.
document, so.
I think
Rather
that-
than tell you what it, limiting it to some category, the marked up document shows you every change. It's in legislative format.
Right. So, I think we're gonna be okay with that, we just gotta do a final review of it.
Okay. We didn't make any change on Article 10. We just left it status quo, so we're still okay with that. The way that it is. We're not recommending a change to that. We are making no change to Article 11. Our position is status quo on 11. You might want to, that's a page that needs to be copied. I don't remember if well, did we make any changes, or that's the way they have it or something?
On 11?
Okay, 11 I don't think you need a copy of, we just haven't changed anything on
Yeah,
that.
status quo.
Right.
Well, I mean, to characterize it, your position, it might be, is it correct to say you're rejecting the union's proposal?
Yes, that's correct.
So that's for 10 and 11 so far.
Yes, that's true. 16, we spoke about last time. Within this document incorporates the changes that we spoke about, and that was having union leave time available. And so there's language in there about the union leave time, and I'll have Kevin copy page 12. Also, on page 13, Article 17, B represents a change that we discussed last time. The language is now in there again to reflect the 2 hours of annual leave that'll be paid to the leave account. Again, mentioning that it's not mandatory, the deductions will be made only when the employee authorizes the deduction. And we can do that as, again, we can just put something out that says, we're going to do the 2 hours unless we hear otherwise. Article 18, the change that I made reflected.
Yeah, the 17, how did you go from half hour to 2 hours, or what was the logic behind it?
Oh, well, it can be a half hour. I think we discussed last time in the session having an hour or two so that you'd have plenty of leave time pool available so that you could do negotiations with that, and also any leave that you needed to take for union business for the stewards and all, it could be used for anything, and union related, that is.
How does one go about authorizing the deduction? I guess what I heard you mention last time is that basically everyone gets deducted, and then in the event that someone wants to opt out, then they opt out after the fact. That's kind of what you described.
There'll be a form to do. for
To
employees.
opt out.
To opt out.
So you're basically in unless you opt out.
Yeah, that's the way that we thought you might want it processed. That way you'll have it, and people will have to make an active choice to opt out.
Right.
I have
So-
a question.
Sure.
If I use this union leave account, will I have to be on leave without pay?
No, that's.
Because not like today, if I work overtime tomorrow, I lose all my overtime. So will I still, if I work overtime tomorrow while I'm on this union leave account, will I still get my overtime?
Yeah, we envision union leave counting toward hours worked if
Okay.
it's, I mean, we'll have to discuss that a little bit because, we may have to differentiate between, I'm just thinking this through and seeing that, it's the difference when you're sitting here collectively bargaining a contract or in a union steward meeting. If you were to choose to use it, to go out of town or something, which I don't, if it's a conference or
No,
something.
no.
It would only be
It
used for
would- yeah.
negotiating
Yeah.
or
Alright.
grievances.
In those two instances, then I'm comfortable saying it's time worked, it's counted
Yeah.
toward overtime. Obviously, if there was a request to use it for something additional, we'd have to talk about that and make sure that we were clear that that would not count toward overtime.
But wouldn't we have to apply for it and state our reasoning for it? So if we come
Yeah.
up with another reason, you can refuse it.
Yeah,
Well, I would say this, I mean, if if the time is being compensated through the union leave account, then that's considered hours worked. If they're taking a leave of absence to go to a convention because they were elected as a delegate and they're taking a week off,
Right.
that wouldn't be coming out of the union bank, so therefore it wouldn't be compensable time, therefore not considered hours worked.
Okay, as long as
That's an
that's,
easy-
that's fine, as long as we're clear on that, then that's, yeah, I just didn't wanna, because we're certainly, I'm comfortable with it that way. And we'll just make sure the language is clear on that and reflects that, and there's no loopholes on either side, so. Article 18, probationary employees, we spoke about, the county's position was 90 days. That was what we originally wanted after our discussions last, 2 weeks ago. I made the change that says the probation, and this is under C, Article 18, page 13, that'll be a change. The probationary period may be extended by the number of days the employee missed during the initial probationary period. Additionally, the Human Resources Director, in consultation with the probationary employee's department or division head, may extend the probationary period for 60 days. So we lessen that from 90 to 60. And then it goes into the plan that you're on, the performance improvement plan. And I think that was all the same language that was there. So the change is the 60 and the change is the extended by the days that they're out. Once again, I'm sorry, there was also a change on page 14 in D as a result of the language that it just was a cleanup. May also be extended when a probationary employee can't fulfill the licensing requirements. So that would be expected, obviously. If we gave you, 6 months and you had to have a CDL and you didn't have your CDL, then we have the right to extend probation to allow you to complete the CDL process, for instance. Article 19, I think, was changed already, but this may be new language to you. I'm not 100% sure, but again, it simply memorializes the language about the 6 employees in the union leave account for contract negotiations. Article 20, let me just talk about that for a minute, because I know that's a TA on here, but I have some concern.
Yeah, so 19, so you're taking out the human resources department being notified, I see that. So that's not something you're gonna be
Oh,
involved.
no, I don't need to be, I mean, unless you prefer it, I mean, as long
I
as
don't
you're
care, I
working
mean,
through
it
the
was always
supervisor. Yeah, that,
processes,
it was struck prior to me arriving, but I don't have a problem not, if your supervisor's the one you have to work it out with, so.
Yeah, while we're on that subject, because we were gonna talk about it anyway, and I guess it's a good time now. The email requirement was something that was put in there, I think at the time, because the thought process would it be easier to notify via email. Barbara DeSimone wanted to be notified via email. And so, the committee members are saying that that's kind of becoming a hassle or problematic, and so I guess the typical way of doing it now is just going to the supervisor, or the preferred way.
That's
For the
fine.
supervisor to fill out the form.
Just to, one point though, that was only one of the reasons the email provision was put in there. The other was for record-keeping purposes, to have an accurate record of when the request was made, and the fact that emails could be retained.
Well, you have
To
that
keep a
list.
record of it.
She has a list, I mean, Kevin has it,
Not
of everybody
all
that
of us
comes
have
here.
access to a county
Okay,
computer,
right.
that's the problem.
I'm not saying you do, I'm just pointing out
Yeah.
that there were 2 reasons why.
Yeah, in
this
case someone
was
gave a
originally
form, and then they never get it back, and someone says, I never got it, and kind of avoid that kind of stuff.
We have one right now.
I never got, I mean, for this meeting, I only received, now unless Barbara got them, I mean, I only received, I think that's the one I got.
I sent you one
And-
too.
I didn't get one this
But
time
that's the
from
argument,
either
I
of you
sent an
two.
email, it was not.
That I'm aware of. I know I got one from
completed.
you last time, for the last meeting, but I didn't get one this time. I've received one. And
Yeah.
but again, that's not my, I can see you here. We have a sign-in
Right.
sheet, and I can absolutely verify that. So I personally don't have an issue if you have it. I want you to work through your supervisor. The supervisor's the one that has to know where you are. I don't necessarily feel like, I'll already know where you are.
And I know in our department too, you have to fill out a form, it has to be signed by your supervisor too.
Yeah.
So I guess when the form is signed and you get a copy of it back, then we have our
Well,
tracking.
the supervisor's responsible for it.
Yeah.
All right, so immediate counter to that would, you know, at least for that part about the email would be to strike that, so.
Just delete the clause by email.
Yeah,
by
this is
the
not a full
employee.
counter, I'm just saying that, you know, so request for leave without pay must be submitted by the employee to the employee's supervisor. So just strike out the words by email.
Okay. I can tell you, we're fine with that, so long as the supervisor's getting it.
But it also says, and to the Human Resource
Well, we
Department.
struck
always-
that
that's
already.
Yeah, it's gone.
You don't see it, but then they're thing to get.
I'm back, I got from August the 11th, that's the
No, I'm
latest
talking
one I
about today.
got. Yeah,
Today was-
right.
oh, she just struck it out.
Get a
Great.
redheaded stepchild at the table, Ed.
So you know,
Let's not talk about hair.
You said it.
And I apologize, and I'm gonna ask Randy this question too, because I know we TA'd Article 20, but it just seems to me, like the very first step where we have a meeting to be with the ACA, unless that was, we don't have the department head, kind of resolving that, and I feel like.
Yeah, that's contrary to,
Yeah, that, what's your, opinion with that?
that's contrary to the practice that we've used in other departments.
Yeah, that is true. Is it okay if we, on the, all right, so step 2 grievance. So first step is you file in writing with the department head within 10 working days, the grievance. But then it says within 10 days, then the assistant county administrator and HR shall hold a meeting. I'm asking if it's okay if we do that. I don't even care if we leave it ACA or designee, because they should be able to designate the department head, because a lot of times, quite frankly, the ACA may not know the issue. And
Yeah, I mean, first of all, how you respond on your side is more your business than ours. Just to give you a little bit of history, I mean, the proposal from the county prior to you coming on was making some pretty significant changes to step 3 arbitration. Those have since been withdrawn, and that's the reason why we signed off as being TA, only because we're fine with keeping the status quo. If you want to take another look at it and tweak something, with respect to how the county responds, I'm certainly open-minded to it. I will make one observation. Most employers, the step 1 is typically something that's kind of verbally communicated. This jumps right into a
Hearing,
pretty
yeah.
heavy-duty process.
yeah,
right?
that's what I'm concerned about, because I know we have one set up for tomorrow, and I think it could have been resolved with the written, response back, but, so.
Probably could have been resolved by somebody talking to the direct,
Well, yeah,
his boss,
yeah.
and just
Well, probably.
explaining to him, alleviating all of that problem.
Yeah, and we don't have that opportunity. Like I said, I'm even comfortable just saying assistant county administrator or designee. That way, myself and, it could be the supervisor if that's the most appropriate person. To get an ACA involved at the first level when it clearly needs to be resolved at the department level is just concerning to me. So I just would like to add or designee. That way we're not in violation if it's not the ACA that's sitting there. And actually then, and then it'll say if the local union under step 2, because it already says county administrator or designee, so therefore you would assume that the ACA could then sit in for that, and that might be the most appropriate. So I just want to add or designee under ACA, both in step 1, where it's the meeting, and step 2.
Are you opposed to just having step 1 just be between the member and the steward, or I don't say the steward because a non-member still has access to this thing. So an aggrieved employee and the supervisor shall discuss the issue. I mean, it seems like we're just, once again, even with the changes you're suggesting, it still seems to be a pretty heavy process for someone who could just say, hey man, I got screwed out of being called for work on Saturday.
Well, but the
It's not that we're gonna
contract,
put it in writing, we gotta get the county administrator, we gotta get the director, we gotta have a sit-down formal meeting.
but the contract is between the county and the union.
Right.
Grievances are about interpretation and application of the contract.
Sure.
So how far down, here's the question, how far down the chain of command do you want people interpreting the collective bargaining agreement and binding you or binding us by it?
Well, I agree that that's a concern. However, if it's just a simple question that can be resolved, because there is no interpretation issue, it's just that the
Right.
supervisor is not even aware of it, and all of a sudden it's
Right.
gone to blue paper, it's gone to HR, it's gone to assistant director. Like
Well-
you said, tomorrow's meeting could have been avoided if we had a process where it's not an interpretation issue.
Well, but at that
Yeah.
point, it's already been labeled a grievance by you.
Well, maybe we'll add, perhaps the answer is to add an additional step as step one, that is that either supervisor or department head, and leave that at just the employee, just within their own department, or even an informal step that allows them to have a
Can I
meeting or
give you an
something.
example?
Yep.
I had an employee that called me up that their supervisor was harassing them. All she wanted me to do was come talk to the supervisor and say, stop harassing me, please. Called up, asked if it was okay if I went over and talked to the supervisor. Your predecessor said, absolutely not. You cannot talk to a supervisor unless it's in a grievance form. Okay, we put it into a grievance form. Now, it could have possibly turned into an ADA lawsuit.
Well,
Just by talking to him and telling him to stop harassing her.
Well, the
Well-
contrary side of that coin is that
If we have
an
a
issue
meeting.
of harassment occurring at a low level of the organization and management up the chain of command being insulated from it by a few employees or a supervisor who might want to cover it up is a big issue for the county and any public employer.
Okay.
We don't want to lose track of those kinds of
Maybe
things.
that's a bad example
Right.
because it's a pretty heavy subject, but let's just say
Yeah.
the subject of something, you know.
Well, like we got tomorrow. I mean, all I could do is go talk to the supervisor myself and show him the contract and explain what's going on. And all of this could have been avoided.
yeah, I still think, again, that and to our point, the supervisor may not be the level, but certainly it might be at the department head level. And again, it's gonna depend on the department, you know, because how they're structured. They may have division heads within the department. I mean, utilities probably a department head. Within utilities, you have the solid waste
Mhm.
director. I mean, so this skips in utilities, for instance, 3 levels essentially of supervision to get to an ACA. An ACA is gonna be like, I don't know what's going on in the plants, I have no idea. I mean, so now, but the other 2 aren't even involved in that, so, you know, we have to bring them in anyway, and like I said, I think we should add one step that, whether it's an informal step, whether it's a step to the department supervisor or something, it should obviously be our call who that is at the department. And it may differ by department, obviously. But I think we do need a more informal step, or at least quite frankly, one back in writing, just to give you our side in writing. It doesn't even necessarily have to be a meeting, you know, that there should be
Definitely
a
to
step
start the
that.
process, I agree, it definitely should be that way. I mean, and obviously, if the 2 people can't get together or they're not willing to work it out, then take it
Yeah,
to the next level.
well, absolutely, then, yeah, it's just, I just can't believe you know, like I said, this is my first one here, I'm like, we getting an ACA involved in this particular issue, which seems very minor. And all of a sudden, it was a scheduling nightmare to get, you know, myself and Don and the employee and I mean, it was because it's
Oh,
goes so high
it
up.
takes an act of
Well,
Congress.
Yeah.
Couldn't it just go by the level of the offense?
Well, then you're getting into, you know, I mean, there are certain times when the supervisor will clearly say, this is above my pay grade and pass it on. But, I mean, there needs to be that level of, you know, that they need to be able to make that decision, I think. And you're right, sometimes they're going to, but I don't think, we can't write all of
Yeah,
the different
trying to
things into a
that.
contract that would cover
And
that.
to Jim, you know, point that, a aggrieved employee and the supervisor may not think something's that big of a deal.
Right,
And if people aren't aware of what's going on, we could have some problematic agreements being made that are in conflict with the CBA and nobody even knows about it. I mean, I get that
right,
concern too.
yeah,
But all that I know is that in most places, the union steward and the grievant and whoever's in charge of that department or area is the first level, and if it grows out of that, because the steward's typically not gonna do anything without me knowing about it. And so
yeah,
if I know about it, I'm probably gonna have my finger on the pulse of it to see if it's something a little bit more major or not. And then, if it doesn't get settled at that level, then it usually comes up to HR and the business agent, you know, and then whoever else you want involved, but, you know, and then the next step, it goes on from there. But, we're open-minded to some changes if you wanna make in light of, you know, some of the stuff we're pointing out here.
okay, yeah, I think I'll just add a step, you know, we'll look at some other contracts and look at what might be a more appropriate first step that's more informal. so nothing's changed on that, so we won't get copies, but I'll have something for you next time, and I'll have that. As I mentioned in the seniority article, your proposal, had things within the seniority article that, some of them I incorporated in the promotion article. Some were related to layoffs, which are in the layoff article, and I'll go through those. So essentially, the seniority article, we are comfortable with the status quo, we're not gonna make any changes. I will tell you on this point, I did go out, I met with, pretty much every department, I think, it's, not busing, but you guys really don't have an issue over there because that's, and there are some serious concerns in department levels, and they gave me, you know, I asked them what types of things in seniority they do, and for instance, at the plants, they do not choose the plants by seniority, but within the plants, I think the shifts are by seniority, that's the way it's.
They've always did shifts by seniority, A
Correct.
licenses.
Right,
And
yeah.
then the B and the C, and,
Right.
which they have just changed that, but that's the way they always used to do it, but.
Okay, not per plant, but per shift, is that what you're saying?
Well, each plant, but they did their shifts. That's the way
Right.
they used to do it by
Right.
seniority for each plant, and they would go by the senior A, then the senior B, and
Okay, that was what I spoke to them about, it seemed like that was consistent with what they were doing.
it was. Now, I'm just saying here lately, there was a change, and I've just started hearing some stuff about it, and I'll probably be bringing that back to you guys. I just have to wait and see. But
Okay.
I guess he's changing the bidding process somewhat, and I
Okay.
guess some of the A operators are starting to get a little upset. So once I know more about it, I'll let
Okay.
you know.
Yeah, it was just described to me as that there's never been seniority for plant assignment. In other words, if you're over this plant or this plant or this plant, but within the plant itself, all the shifts are bid by ABC by seniority. That was how it was described to me.
Right, and
So-
so if you're the senior A, you can pick what plant you wanna go to.
Well, no,
That's
that,
how it
okay,
works.
yeah,
Well,
see, that wasn't described. It was, the shift was yes, but not the,
Shift in plant, yeah. It's
Okay,
always
that-
been that the A guy can go, well, let's see, I'm at Embassy and I wanna go to Deer Park. I want
Okay.
that shift.
we'll have to chat, yeah, because that wasn't the way that I
Yeah.
think that it was described to me as past practice, quite frankly.
Well, just, you know, I mean,
Past practice,
to
exactly.
go and get an opinion about, you know, we could have told you that. We could have told you the seniority is now being applied in the manner that, or to the degree that we want it to be. Okay, so the idea is we're trying to make a change to the culture. We're trying to make improvements to the status quo. So to, you know, to simply get a response of, well, we just don't do that here, you know, no kidding, you know.
No, that wasn't what I was asking for. I was asking them for, reasons that, you know, like, okay, so if we wanted to do it in, you know, I mean, to Tom's example in Fleet, we're all, you know, the new guy does the oil changes, that's not gonna work for them, and we had some, you know, pretty significant discussions on the limitations, and quite frankly, from a practical standpoint, okay? So, you know, first of all, some mechanics are ASC certified and some are not. Some mechanics, when you hire them off the street, have 0 years of experience doing anything related to anything mechanical, and maybe those guys are doing oil changes, but they have to learn. Also, you could hire a guy that's been working for Ford Motor Company for 15 years as a lead mechanic and knows more than, quite frankly, everyone in our department. So why would I bring him in and have him do just oil changes? I mean,
Well, first of all, we didn't have a proposal that says, new guy does oil change. We had a proposal to say that we need to recognize seniority for a lot of different things, and we need to sit down and work them out. So, new guy does oil change is not the pitch, it's not something that is in writing or even in
Right.
it's just one example of how one particular employee, you know, feels that some injustices are. And so, you know, maybe the guy who comes from Ford with 25 years of lead mechanic experience, we don't know why he doesn't work for Ford anymore. Okay, but the thing is that, okay, he can do a job and that's great and he's got all this experience, but you know what, he's coming to a place where a lot of other people have comparable experience, at least enough to do the job. And so if someone is that much of a superstar, maybe you need to pluck them out of the rank and file and put them into management, and we certainly couldn't stop anything to do, you know, your desire to do that. But, you know, I was hoping for something a little bit, because I mean, am I hitting fast forward too quickly, where I thought you said you were interested in keeping the status quo? Is that what your response is?
oh, well, no, I mean, because like I said, I told you that in some of the other, you know, you had the promotion one in here, and you had the layoff one in here, and you said, so I'm saying, I don't wanna make a change to this article where we talked about the changes. I did plug some stuff into other articles that we can talk about. So right now, I have not made a change to this article. But I wanted to let you know, it wasn't because I'm coming back saying, hey, no, I checked it, it's not gonna work. I mean, I literally have example after example after example where they're saying, if you do this, we're gonna be, you know, tied because we're not gonna be doing it. And also, I went to Hernando and I checked to see how it's working there, and quite frankly, they're having a lot of problems. So, you know, and to that extent, I mean, some of the language that you've asked for, you know, I have specifically asked the supervisors, HR up there, and they've indicated, you know, quite frankly, they're having some major issues. So.
I guess it all depends on who you talk to and who you ask.
Yes, absolutely.
Yeah, and the bottom line is, I
Good
mean, as
question.
recently as yesterday, I was
Yeah.
on a call with,
Yep.
with the, Director of Department of Public Works, and
Mm-hmm.
so we, you know, there's people in every organization. You can ask some rank and file employees, you know, what do you think about saying, oh, that sucks, I want nothing to do with it. Okay, well, you pay dues? No. Well, no surprise. Okay, you may ask a manager who's in, you know, in a situation where they have no use for seniority, or a supervisor that has no use for seniority because they're not doing absolutely what they want to do all the time. So, you know, I understand, you know, that we're not going to go from 0 to 100 miles an hour all at once, but we have to do something, Barbara, with this. We have to do something with this, because if we don't, we're not going to have a contract.
Yeah,
I'm
and I,
just
I mean,
being
the
brutally
blanket,
honest.
I can just tell you that the blanket statement is not gonna work, because it can't work, because I already got, I mean, I'll give you another example, so facilities, right? So there's maintenance tech, 1, 2, 3s, and 4s, okay, right now, that's essentially the way they're broken down. So if we created a seniority list, or overtime list, or anything like that, it can't work for this reason. So within the 1, 2s, 3s, and 4s, they have different disciplines. They have electricians, they have plumbers, they have carpenters, and they have HVAC guys. So if you created a list that had all the maintenance tech 2s on it, right, and then had an overtime issue and went by seniority, it might be the completely wrong guy. So then you'd have to break it down by discipline, and then you'd have to break it down on, I mean, it's just, so for that reason alone, you can't put a statement that says, oh, well, when all else fails, department seniority.
First of all, the proposal, once again, wasn't that overtime is the rule by seniority. That's not what the proposal is. The proposal is to sit down department by department and work things out that work for that department. That's what the proposal is.
No, it goes further, because it says that, and if that fails, in other words, and if you don't agree to what we're saying,
Right.
then it goes automatically to department seniority. And I can't put my departments in that situation where all of a sudden it's like, well, we can't come to an agreement, so by the way, it's.
Provided the employee can do the job. So if you have a plumber and the overtime assignment is an electrician, they wouldn't qualify for it anyway, even under the fallout fails provision of departmental seniority. However, if you have 5 plumbers and there's plumber overtime, and we don't work something out more specific, then yeah, departmental seniority for the 5 plumbers for the plumbing job that is being offered. And that's just fair. Now, if you have a reasonable argument to say, well, John, that doesn't make sense for us because we have 5 plumbers, but 2 of them east and 2 of them west and 2 of them central, and the overtime's in central, senior guys in west or east. We recognize that. Okay, it doesn't make sense to bring a guy 25 miles or whatever to go work an overtime assignment. It's not about handcuffing the county. It's not about chaining the county into being unproductive. It's the opposite. It's about having a fair system for employees. And again, if you know, if you have no interest in doing that, then we're not making any advancement. We're not gaining anything.
Well,
So-
and a lot of the, like in parks, they use more of a rotation list for seniority, and
Well,
the
there you go.
employees are very
There you
comfortable
go.
with that.
So we'll sit down with the whoever's gonna be representing, you know, parks in terms of being a steward, and say, well, what's the general vibe? Well, we rotate over time and we like it that way, John.
Okay.
Hernando County Utilities is that way, okay?
Right,
Job assignments are done by basically who's skilled in doing what. And overtime is rotated, or it's basically whoever's doing the job. And that works for them.
right, but, and that's what I'm saying, and that's what I was suggesting last time, and quite frankly, I went back and I looked at the impasse stuff from last time, that's exactly what the special magistrate suggested, is sitting down, I know it's a little time consuming, but at least it wouldn't stop the flow of this contract, is sitting down and saying, you know, the thing is, I can't put something in the contract and say, okay, but if we don't have a deal, it's all the department
Well,
seniority,
then
because that will.
what's to keep the exact same thing that has happened since we started bargaining from continuing to happen? What's gonna keep it, when there's nothing, no one held accountable to make any cultural changes, in terms of seniority? What is going to, compel the parties to get something done? Because if it's just a meeting of sitting around chit-chatting and talking about things, and then at the end of the day, the county doesn't want to do anything different than they've been doing all along, and the union is not making any changes as we want to, what's being accomplished? What's being accomplished? And that's,
Well, to your point, I don't know that changes need to be made, because as I just mentioned, so in parks, I said, they're using a rotating system, they think it's great. You said, oh, then we'll just keep doing that.
no, I didn't say that. You're not listening to me. What I said is we'll sit down with the union steward and actually find out from the workers what they feel. But you talked to probably a management person in parks and said that everything's fine, right? You surround yourself by a bunch of yes men, yes women, you're gonna probably get the answer yes. So,
But I think she did ask last time for some valid examples of where this was misapplied or where you think there can be some opportunity to improve. And I think that was what you had asked for, and that wasn't
I
provided.
explained it was a futile waste of time to engage in asking departments that are doing things a certain way, how they felt about doing something differently. I don't understand the value in that. If every single supervisor was interested in doing the right thing, every single management person was interested in doing the fair thing, we wouldn't be here talking about this. So the fact is, that this committee and this union, by the majority of the surveys that I've received, want to see changes. They want the status quo to change. So to simply just say, well, I've checked with everybody and status quo is just fine, simply doesn't work. And quite frankly, is being somewhat, I don't know, just ignoring the issue, just kind of trying to kick the can.
I am the steward for Parks and Rec, and I don't know who you talk to, but there has not been overtime in Parks and Rec for the last 5 years because they change everybody's schedule.
So working overtime is probably not a scenario.
I do,
So there has not been overtime in Parks and Rec for the last 5 years. Because they change their schedules. They tell them take off Monday and come in at 8 o'clock Saturday night to work the lights or something.
I do think no matter what department you talk to, if you're only talking to the managers and supervisors, you're never gonna hear what's going on underneath those people. Because, and the people who work underneath those people and report to those people are the people who can tell you what's really happening. And as far as their workforce and their satisfaction and their operations and their
They're not
ability
scared
to
for
perform.
retaliation. We talked
Right,
about that earlier.
yeah, right.
Well, I think that's absolutely true. I think you guys are maybe getting, one complete perspective only on your side. I mean, to
We
the
organized, I
extent.
don't mean to interrupt, but I'm
Yes.
going to. We organized this union primarily by and large on the subject of seniority rights. This whole thing came about because employees were not having seniority honored. Pay was secondary, benefits was secondary. We didn't organize, and we never do, purely around money because it's a waste of time. You organize around money, employer gives a raise, the whole campaign goes down the drain, and the whole thing is a waste of time. We organize around real significant issues that we have the ability to change through collective bargaining. Seniority was the issue we organized around, and it's the one thing that the county doesn't seem to want to make a change with. And so, to start implying that maybe we're only talking to our yes people, the only reason we're here is because of the things that have been happening over the last several years in terms of favoritism, nepotism, and just general unfairness. Those are the reasons why we have this seniority language that we keep talking about over and over and over and over and over again. And to just simply say that, yeah, that's just not gonna work here, again, it's just not going to end up with a good agreement.
And a repetition of retaliation against any worker in the rank and file who would challenge whatever the supervisors or managers say.
Can you give me an example?
In plenty of examples. Well, I mean, for example, yesterday I happened to attend a forum given by Public Services New ACA, Kathy Pearson, and she was saying that customer service is a very big issue for her.
Right.
And it is for everybody who works in public services. I can tell you that there are people who've been, for example, in libraries, who've been in the system for a long, long time, who are in the quote rank and file, who are out there helping the public every single day. And we know, well, one, we know and we see things where we're not able to really do that as well as we could be doing or should be doing or whatever. But we have a supervisory level between us and the county. And if we challenge that, and Kathy Pearson's own words were, you know, to follow the chain of command. If customer service isn't working, let them do their job. But if they're not doing it, then go over it. That's never going to happen with people who've been here for more than 4 or 5 years.
What do you mean? I guess I don't understand what you're saying.
What I'm saying is if we see a problem that we think needs to be addressed in order to serve our patrons better, or that is a gross problem perhaps, sometimes, okay, I would say in some cases we've had issues with library safety or public safety that maybe the lower workers think is a problem, or even actually problems with fines. The way our system works, we have a constant problem with the way fines are with patron satisfaction with the way fines are processed. And I mean, that's a specific problem that we as a system have a problem with. And a lot of us think that it could be better explained to patrons, and the system that we have could be better presented, could be more efficient so that patrons can clearly understand it and that we can clearly explain it to patrons.
Right.
But we don't have that kind of a system.
But you mentioned retaliation. I guess I'm confused about how one.
If we make complaints, if we make complaints against people who we directly report to, whether it's supervisors or managers or department heads, they will come back and scrutinize the person who does the complaining, much more than anybody else. And as far as favoritism, that's where favoritism rears its head, in that they will pick, their designated favorites, and then sort of, anybody who complains is sort of marked, and
Yeah.
marked for complaints, marked for poor evaluations, and we've seen it happen, and people have even lost their jobs.
Let me give you the manager side of that whole favoritism argument. And I'm sure you've heard it before, and we could sit here from now until 2050 and never agree on this issue. And because this is, managers by and large get also tired of hearing about that, favoritism. I can tell you that from our perspective, it has nothing to do with, it has, favoritism, these are the people who are really good employees. These are the people that when I say to them, hey, could you do this? They go, oh, absolutely, I'll get it right done for you. And then there's the employee that says, oh, God, I got to do that now. Favorite? Yeah, okay. I mean, this person's a better employee.
Yeah,
And
just
then-
because they say that, or because they're actually, because
No,
they.
it's their job performance. I mean, you have
Okay, but
people who
are they delivering?
Well, I mean, but-
Are they delivering on what they're saying to the supervisor?
It doesn't, like I said, you guys will never get me to agree to that side, I'll never get you to agree to my
Well-
side, but just understand that there's always two arguments to the favoritism. Everybody always says, oh, it's favorite, and I heard that, they go
Okay.
fishing together, so
Okay.
therefore they're buddies. No, they were a good employee, so therefore the
Yeah.
supervisor liked them, and therefore invited them fishing.
I can
Yes,
tell
special
you as
privilege.
somebody who's
No,
managed.
it's not
Because they got a
special
nice
privileges.
attitude and a nice smile. And
Right.
Yes, a better
enthusiastic.
attitude is absolutely gonna get you
Enthusiastic, so
more.
they get special privilege.
Can I throw a monkey wrench?
Enthusiastic, it's a better attitude, that's all about
It's just
job
natural.
performance.
But
Right. It's
that
natural.
will
They
happen
get
to any
special
employee at
privileges.
first.
Right.
that will happen to any employee, and every, you know, because
I don't-
because when they come in, and I think every employee pretty much hopes for a good experience, and if they don't get one, or if they've performed well, and then all of a sudden there are changes in their environment where they get shoved to the side, and there's somebody new who supposedly has more qualifications than they do, according to the supervisor, then all of a sudden they're retaliated against.
Yeah.
They lose out. You know,
I just got a simple, I wanna make a comment, and then I wanna ask a question. It's a pretty pointed question. The comment I wanna make is that Hernando County first agreed to the language that has been proposed to Pasco in 2009, okay? And like most first agreements, it didn't happen overnight. So 2009 was a result of, you know, quite a bit of time negotiating. Our language was in the 2009, 2010, 2012 agreement. 2012, 2013, 2014, I think we have a 2-year agreement. And it's in the 2014 to 2017 agreement. And never once did the county propose to change it, to get rid of it. So, with that being said, don't you think that if it was that problematic, if it created that many issues, that we would have been going to impasse over the language? And so, you know, and so that's my statement. The question is your proposal that you're not interested in changing the seniority rights language? Is that your proposal?
We can't make a blanket statement on seniority.
Okay,
We
do you have a
certainly-
counter proposal on what would work for you with regards to seniority?
Well, as I mentioned last time, the committees, I mean, we could like I said, I don't mind going out and talking and seeing what will work in the departments, and quite frankly, when it went to impasse last time, that's what the magistrate suggested, that was his
The magistrate
recommendation.
suggested pretty much the language that we're proposing, that we're gonna sit down and work on a system of seniority.
Okay.
Work on a system of seniority, not form a committee to talk about seniority. And there's a difference. If we have a directive from a special magistrate that says the parties need to sit down and work out how seniority is going to work, that means seniority is going to work. And we need to work on how it's going to work. Not a matter of sitting down, forming a committee and talking about how it could work or how we don't want it to work. It's about how it's going to work. And so, I think I've heard enough. Can we have a caucus for a few minutes? Do you mind if we just talk?
Hey, Barbara, I'm gonna send you a video from last year from when the county lawyer told John and all of us here that, about seniority. He says, "You don't wanna go there, John. Live to fight another day for seniority." Well, it's a year later and we're fighting for it. And I'll send you that
Taking a
video.
break at, you done? I'm sorry, didn't mean to cut you off with your comment.
I believe I'm finished, Jim.
Okay. Taking a break at 10:34.
I don't want to call you travel agent.